Hello, everybody. Happy Friday. Happy Veterans Day. And thank you for joining us. My name is Ashley Jones. I'm the Managing Director of Community Programs here at the Venture Center. And we've got a great workshop for you today on business succession and estate planning 101. We've got three attorneys from Wright Lindsey Jennings here with us to cover a range of topics from wills and trusts, business succession, special needs planning and guardianship, to probate, estate, trust administration, and more. Before we dive in, just a few programs the Venture Center has coming up. Next Tuesday, November 17th, is the 2020 GEW Central Arkansas Pitch Event. So if you haven't already, be sure to register to watch that event. We have 9 entrepreneurs that are going to pitch their businesses for prize money totaling $18,500. Pretty awesome. Also, we have a Lift the Rock next Friday, November 20th, with a focus on the retail space. So be sure to register for that as well. All of our programs can be found on our website by subscribing to our newsletter and following us on Facebook and our other social channels. So we encourage you to do so to keep up with all of that programming going on. Lastly, a big thank you and shout out to our community program sponsors. We've got Wright Lindsey Jennings, Frost, Simmons, and the Little Rock Chamber. Thank you for their continued support for all of our programs. With that being said, please welcome today's guests, attorneys Kayleigh Dulaney, Kirby, Miraglia, and Sidney Leasure from Wright Lindsey Jennings.
Hi, thank you for joining us today. We are so happy to have you with us and happy to talk with you a little bit about estate planning, the documents involved with that, some different considerations between, planning with wills and planning with trusts, and also some considerations when you're talking about business succession planning, which goes hand in hand with estate planning. We also want to say a special thank you to our veterans today. We appreciate you today and every day, and appreciate that, if we have any veterans with us, thank you so much for your service. I am going to share my screen with y'all and get started talking about estate planning. So I'll start by saying I think everyone needs estate planning. We get a lot of questions about who needs this, or people who say, oh, I don't think I need an estate plan, or I don't really have a lot that needs to be passed, or people think that estate planning is only for very wealthy individuals. Estate planning is for everyone. It is for individuals. If you, especially like I'm not married, my estate plan designates what I want to happen with, the assets that I have, but also there's a lot of considerations that we'll get into as far as contingency planning if something were to happen to me. For couples, I think prenuptial agreements are great for everyone. It's good to make a plan when everybody's happy and getting along. But we also do a lot of planning, as people get married, or when people begin having children. It's something that's really important. It's very helpful for families that are blended families, where you might have, stepchildren, a second marriage, and you really want to be clear on how you want your assets passed in that situation. It might not be, by law, it might not be what you would want. So I think it's very important there. And then for small business owners, which we will talk about that later in the presentation, about business succession planning and planning on how that will work with your small business and how you might want your interest passed. So basic estate planning documents. We've got trust, a last will and testament, which everyone needs, a living will, healthcare power of attorney, durable general power of attorney. You might not have a trust. Kirby is going to talk to us in a little bit about considerations around having a trust versus only using a will. And there's kind of pros and cons to both, and she'll walk you through those. But before we get to that, I will talk to you about some of these other kind of ancillary documents, but documents that we do for everyone that we prepare an estate plan for. So before we get to the meat of that, we collect, in order to prepare your estate plan, we collect a lot of information from you. The questionnaire is very lengthy, but it's really important for us to get an idea of what your wishes are, how you want to, make gifts or pass any assets that you have. If there are any tax concerns, that's something that we want to address. I'm a tax attorney. I always want people legally paying as little taxes as they possibly can. And then talking about, your family and your family situation, and, if you have small children that you want to seek guardianship, or outline who you would want to be their guardian if something were to happen to you, and things like that. And this is very important because every estate plan is tailored to you. It's going to be tailored to what your wishes are, what you're comfortable with, and no two estate plans are the same. So that's why we have to get a lot of information from you, and everything's going to be tailored to you. So one thing that we sometimes do, and again, Kirby will talk about when we do this versus when we choose to just do a will, but we often set up a revocable trust. So a revocable trust holds your assets during life. You can operate out of a revocable trust the same way that you would operate with your normal, day-to-day ownership, business, personal business. And so what we do with that is transfer your assets into the revocable trust. You can own your house through your trust. And there are a lot of different ways that we can do that to address certain needs, whether, you, like I said, if you have small children, if you want to direct, you would like to be the guardian of them. Trusts are really good for setting up different distributions, or if you want to give distributions to people at certain times or certain ages, that's something that we can do, and something a lot of people choose to do. If you have like a blended family and you want to separate, assets for this, this spouse's set of children and this spouse's set of children, that's something that you can do as well. Or I'm working on an estate plan right now where it's a husband and wife, and the husband has there's a trust that's set up for his family where the assets that are passed to him can only go through his bloodline. So even though the husband and wife want all of their assets otherwise upon his passing to go to her, or on her passing to go to him, we have to, make some special provisions to account for that money that's earmarked for only his lineal descendants. So there's a lot of different things that you can do that way. It's very, very flexible, and again, it's something that is going to be tailored to each individual. Now, a will is something that everyone will have. If we have a trust, then your will is going to just pour everything into your trust. And it's kind of a catch-all to make sure that we get everything into the trust that, maybe wasn't transferred in. But without a trust, you have to go through the probate process and probate the will. And other than the probate process, the will and the trust do a lot of the same thing. So, we can make those guardianship designations. You can do different distributions. You can set up a trust within your will, a testamentary trust.
Sidney, you're on mute again. There you go.
Is it working? Can you hear me?
Yes.
We can now, yep.
Okay. I lost it, somehow it's disconnected from my AirPods, so I think I'm sorry. If y'all can hear me, I'm gonna keep going. So I think I accidentally jumped ahead. Anyway, you can make any bequest that you would make under your trust. You can do that also under your will. It just will have to go through the probate process, which Kirby will talk about. Next is a living will, and this is an end-of-life directive. This comes into play if you have an incurable, irreversible condition that will cause your death in a relatively short period of time. Ashley, I saw where you asked if I could speak up. I think I don't know if y'all will be able to hear me, but I'll try to. Sorry, the microphone on my laptop is kind of less than ideal, which is I was trying to use these and it's disconnected. So your living will allows you to direct your medical decisions. So that is something that you want to do. I think the best example of this is the Terry Schiavo case. Y'all might remember it's been a good stretch of time now, but in that case there was a woman who had gone into a coma. It was irreversible, and no one, it was unclear what her wishes were for her, kind of end of life care, and it ended up being a legal battle between her parents and her spouse. And a living will is how you can avoid any confusion in this area and make sure that your wishes are met. Allows you to direct withholding certain care, all care for your comfort. Anything that would make you comfortable is something that is still in play, but this is like, if you maybe were in a coma, you might not want to be put on dialysis, or you might not want to have chemo or something like that. And so this document outlines what your wishes are, and I think is really great for your loved ones, that they don't have to make that decision. There's a lot of tough emotions if you do have a situation like that. This allows them to, they can respect your wishes without having to wonder what that might be, or without having to make those decisions themselves, even if they know what your decisions are. Next is a healthcare power of attorney. So this is a directive where you choose someone to be your attorney in fact for healthcare decisions. So this is someone who you can appoint one person or multiple people, or you can appoint, this person, and if not this person, then, like if you want it to be your spouse, but if not your spouse, then your sister or something like that. You can have kind of a succession, but the person who is your healthcare power of attorney can access your medical records if they need to give informed consent. If you're unable to give informed consent, that's something that they can do. They can discuss your treatment with doctors, and we see this happen. If somebody is incapacitated, that someone, a loved one, can make those decisions for you. But it also happens in non-catastrophic situations. So if you are, if you're having kind of more minor surgery and while they're in there, they see something that, you know, was not part of the care that you consented to, then they could, your healthcare power of attorney could give informed consent and say, yes, you know, while you're in there, go ahead and take care of that. And so, you know, we see it come up in non-catastrophic situations as well. And the kind of flip side of that is a financial side of that is durable general power of attorney. So this is somebody who is appointed by you, and it can be different than your healthcare power of attorney. It can be the same if you want. They're completely different documents, but this is someone who would make financial decisions in your shoes, and they can authorize payments.
Sidney, I hate to interrupt you, but we can't hear you. You need to get a little closer to your computer.
Okay, let me
Or take a moment to reconnect your.
pass it over to Kirby for now.
Yeah, I'm happy to take over. Can everyone hear me?
Yes.
Much better.
Okay, great. So in, like Sidney was saying, with a durable general power of attorney, this is more for financial decisions. So you could allow someone, so if you were, for example, in the hospital for that minor surgery and you had to sell real property and you had a closing scheduled, this person could take your general power of attorney and go to the closing for you. So it would allow you access over somebody's finances. You can limit when the effective date of this document. For example, if you are, you know, in your 30s, 40s, it's very likely that you probably don't want someone just to be able to have access to your financial assets at this time. So we would limit it to only upon your incapacity would someone be able to access and use this document. Versus if you were in your 80s or 90s and the purpose was to allow people to help you, then we would make it effective immediately. So again, this has a wide application and a lot of things that someone can do, not just accessing your bank accounts, but also assisting with other estate planning documents. Sidney, you want to go to the next slide? Okay, so I think this is actually where I was going to take over anyhow. So you'll hear these terms a lot in regards to estate planning and the probate process. So intestate succession would be you pass away without a valid will. So you have no say over how your assets are to be distributed and who receives them. The state decides that based on a statute. That would require that you go through the probate process. Testate succession would mean that you pass away with a valid will, and that gives you the power to outline how you're going to distribute your assets. With testate succession, you may still go through the probate process if you only have a will, but if you had a trust, and we'll get into that in a little bit, the trust would allow you to avoid the probate process altogether. So just so you can kind of be familiar with these terms in case you hear them because they're used pretty regularly. Let's go to the next slide. So a little question for you. If you die intestate, so remember without a will, who does the state say that your assets go to? Surviving spouse, parents, children, or your siblings? Does anybody want to just throw an answer out there? Everyone wants to be quiet. Okay, then I shall tell you. It's actually your children in the state of Arkansas. I think a lot of people tend to think that it is your surviving spouse, but Arkansas is not the norm on that. So your children will actually take over your spouse. Your spouse is still allowed to have some type of election against your assets of your estate, but the majority of your assets go to your children. Quick little war story. We had a client whose husband passed away and the house was solely owned in the name of the husband. So he died without a will. He died intestate. So his children actually inherited the house that his family lived in, which children can't own real property. So now, on top of grieving the loss of father and spouse, the mother had to have a guardianship proceedings over her 2 minors to hold the real property. So when she got married, 10 years later, children are still a minor, guardianship is still in place, and she has to seek court approval to sell the real property. So it just kind of complicates everything if you don't have estate planning tools in place. Let's go on to the next slide. So Sidney mentioned earlier that there's some differences in trusts and wills. So keep in mind, it's personal preference. Whatever you feel more comfortable doing is what we'll do. But just to make sure that y'all understand kind of the 2 sides to why we prepare a trust versus a will, but let's kind of go through some of these. So for privacy purposes, trust offers more privacy. There is no filings with the court in order to administer the trust. With a will, you of course have to probate your assets. If you so whether you die with a will or without a will, you would have to probate your assets. So the trust is the only mechanism that allows you to not go through that process. Wills typically require, or excuse me, probate process requires that you file an inventory and accounting. Those are public documents. So you are itemizing your assets and the value of your assets, and anyone can go and access that information. There are ways around that in the sense that you can file certain waivers, but if everybody is not on the same page and agreeing to everything, then all of those requirements will have to be made. Timing purposes. A trust takes just a few months to administer, to gather the assets, to see what's out there, and then start trying to distribute them in accordance with the trust. There are still certain requirements to administering a trust, certain notices that have to be given, but that would, again, still offer that privacy aspect by those notices going directly to the beneficiaries named in the trust and not to the general public. With a will, again, the public has access to it, but a will and a probate process takes about 8 months to a year. And that is if everybody agrees to everything. We don't have to file inventories and accountings, and we don't have to have certain hearings that are typically required. I just completed one that took about 4 years, just because of everyone was agreeable at first, and then somebody got mad and they revoked their waivers, and we started to have hearings. So we ended up having, I believe, 9 hearings because everyone just kept fighting. And at that point, it was just fighting to be fighting. So keep in mind that that can always be prolonged, but a typical, if everyone's agreeable, 8 to 12 months. Cost considerations. Although there may be some additional costs on the front end with a trust, it's not significant as compared to your general estate plan. As Sidney spoke to earlier, the same type of information that we would put in a trust, we put in a will if you choose not to do a trust. So the cost is increased minimally in regards to how you prepare that. And again, the administration on the back end, because it's so small, such a smaller window, and there's not all these required filings, the administration on the back end is also significantly less. With a will, the cost of probate typically is $5,000 to $10,000, and that's if everyone is agreeable and on the same page. So keep that in mind whenever you're looking kind of the cost benefit analysis too. The time and the money typically play a big factor in generally why we choose to use the trust with a lot of clients. We can go to the next slide. I've talked a little bit already about the probate process. Again, the biggest thing for us is it just takes a long time to get through the courts. The reason for that is there is a 6-month claim period required in the state of Arkansas. So you have to leave the estate open and allow anyone to make a claim, whether that's, for general purposes of taxes or credit cards, medical bills, anything of that nature, your mortgage company, they would make a claim against the estate. And you would still, and then we would be given the opportunity to pay those claims before any assets are being distributed. Not saying that those claims are not valid in a trust process, but you are actively notifying the claimants during the trust administration. We talked a little bit already about court appearances and filings and how a lot of this can be waived. One thing that may be really beneficial in regards to business succession planning as well is a personal representative will be required to seek court approval to continue the operation of your business. If you have a business that is all you, for example, my husband, he is in construction, he owns his own business, and it's just him. There's nobody else really that's going to want to buy his business because he is his business. Now, there's assets that can be sold, but if we wanted to continue the operation of his business, we would have to seek court approval if he did not have a trust in place and proper estate planning. So like this says, we have to seek court approval every 3 months. So if you have a business that has to be maintained and you're continuing to operate it, you still have people who are running the business for you. That is an added expense, as well as an added, who has the authority to operate the business, because once that order ends after 3 months, then nobody has the authority to continue to operate your business. So just be mindful of that as well when you're thinking about estate planning and business succession planning. Okay, next slide, please. One thing that I just like to make sure to point out is moving forward, no matter if it's Wright Lindsey Jennings or somebody that you have a personal relationship with, set up an appointment with your attorney. Have a discussion about your estate plan and what your individual needs are. And this will change. So this may not be the document that will stay in place for the remainder of your life. What we typically say, grab a glass of wine, sit down, do a status check every year, and think about what things have changed, and does that impact how your estate plan is currently written. You have additional children, you now have grandchildren, whatever the case may be, you've married, you've divorced, let's talk about anything that's new. On average, your documents will need to be updated about every 5 years. You'll notice that some major life change has happened. And one thing I do want to point out, and I don't think I have any slides on this, is also consider if you have anyone in your family that has special needs that you would be leaving any assets to. And I don't know if Kayleigh is going to be mentioning this at all, but Kayleigh specializes in that as well. She has a child with disabilities, and so she is very familiar, even from the front lines, as to making sure that all of this is properly in place. But you could, if you leave assets to a child with disabilities, you could make their benefits, you could disqualify them for benefits, governmental benefits. So we want to make sure that that's definitely a consideration. But just to kind of close this out, just have a conversation. And I know it's not an easy conversation to have, because you never want to talk about death and where your assets are going to go. But just take that opportunity to move forward and to have that conversation. Kayleigh, I'll turn it over to you.
Get myself unmuted. Can you hear me? All right. Yeah.
Yes.
Before I jump into discussing some of the business succession planning process, I'm going to piggyback off of what Kirby mentioned about special needs planning. We didn't talk about that a lot, and we're kind of covering a whole lot of topics in this session. But I did want to make sure to kind of piggyback and push the importance of that, particularly when you have a child or a family member that has special needs. Like Kirby said, I have a son who has special needs. My almost 4-year-old has Down syndrome. And so we are very much in that world of programs and what benefits he's potentially eligible for. And what a lot of people don't realize, parents that are in this world realize, but family members or other people that might potentially leave something to your child or to a family member are not aware of, is, there's very low thresholds for triggering issues that would, hurt a child's eligibility. And a big reason that some of that is so important is because some of these programs are only available, or some of these, community programs are only available if your child is in one of these benefit programs. So we have, I have clients that come to me who, might have a child with special needs that wants to participate in a particular, job training program or an independent living program when the child is older. And if, the parents or the family might be willing to pay for that program out of their own pocket, but the child cannot get into that program if they're not participating in a certain, governmental benefit program. So it's not necessarily always about need, but sometimes about these enriching programs that are great for our loved ones' lives. So it's always important not to just look at your own estate plan when you're thinking of a family, but to look at your other families' estate planning as well. So when my son was born and we were reevaluating all of our situation, I visited with my parents and my grandparents who had, intentions on leaving things to their, grandchildren or great grandchildren. And I made sure that their estate plans were updated so that anything that might come to my son would come to him in the form of a special needs trust. So it wouldn't hurt any potential benefits he might be receiving. So we'll jump in now into business succession planning. And this is such a, just like estate planning, this is a process that is so unique to the family and your business. And so I'm going to talk about some kind of a general plan structure and some things that you need to be addressing. And all of this is going to be very tailored and specific to your business, how your business operates, and how it's owned. So we'll jump in, and Kirby and Sidney, feel free to jump in and interject anytime throughout the process. The first thing that I'm going to outline is just kind of the general steps that I see in the business succession planning process. The first is to just evaluate your goals and objectives, and that's very similar to what we're doing in the estate planning process. Identify your actual successors in the business, whether that be family members or other, business partners, but identify who those successors in the business would be. Establish a decision-making plan. That's meaning, when you're gone, how are business decisions being made? Where does that decision-making authority go? Develop a team of advisors. Establish an internal business succession plan. So once we've got our big overarching objectives, we need to figure out internally how things are going to operate. A lot of times people, look at the big picture of who is going to inherit this business or who is going to purchase the business, but not how is the business going to continue to operate internally afterwards. And the last is to review the owner estate plan. So no business succession plan is going to be successful unless it coincides with the owner's estate plan. So that's really important when we're thinking about this entire process. And as we're talking through these steps, everything kind of comes back to the owner's estate plan. So it's really important for you when you're working with your team of advisors and your attorney to make sure that, that succession plan, needs to be part of your estate planning discussions from day one. So I'm going to let you jump to the next slide, Sidney. Okay, goals and objectives. Really just kind of like when we're talking about an estate plan, who will you pass the business to? If to family members, how will the transfer impact their lives? Are they even interested in running the business? Do they have the skills to run the business? I have several clients in this position that, will be, moving on in age, ready to kind of retire and stop. And they've always, assumed that they would pass their business to family members, and maybe their estate plan is drafted that way. And then, we have a parent who might be, in their 80s and ready to 70s or 80s and done with the business, and none of the children ever really expressed an interest in operating the business. So we're having to step back and go, okay, well, if nobody is interested, what are we going to do here? It might make sense to sell the business instead. So it's really, when we're talking about, in order to have a smooth transition in the business succession process, we have to be realistic in having those hard conversations about who is going to be interested, who's going to take over the business. Because I have seen situations where, parents did not want to have the discussion with kids or family members who they intended to leave the business to, and just always assumed that, they would want that. And especially, as a business grows and gets larger, you have to be thinking about, how is this going to impact not just the people that I'm considering transferring the ownership interest to, but all of the employees that work for the business. What is going to happen here if I'm not making sure that I'm leaving a line of succession in place for somebody to take over? So really outlining, who do I want to give the business to? And that goes back to an estate plan consideration of, this is my wealth. This is this might be the largest asset that's owned by the estate, and I want my kids to benefit from it, but my kids don't want to have any interest in being involved in the business. So it's a matter of figuring out, if they don't, what steps do we need to take, and when do we need to take those to make those, to achieve those objectives. Okay, next slide. Identify successors. This kind of ties into what, I kind of just went on and went on to this next topic, piggybacking off of the previous. Will the successor be a family member or an outsider? Will interest pass to other owners? So a lot of times when we're talking about identifying successors, we might have a business that's wholly owned by one family, and we see that a lot. But we also see situations where we have 2 business partners or 3 business partners that each own in a business equally. And in that situation, this business succession process can be even more detailed, because at that point in time, we're not looking at just what happens when one owner passes away, but then we have 3 different families to consider. So as an example, I've seen in situations like this where, one business partner's family is involved in the business, is very clearly going to step in and be a part of the business after that family member passes away. And then another side, another partner's, kids don't want anything to do with the business, and the business partner doesn't want his kids to have anything to do with the business. And so in that situation, those conversations need to be had with the current owners. And there's a lot of steps that we'll talk about moving forward, ways that we can structure that to make sure that the owners' joint interests and joint objectives are accomplished. So, and it might be, one owner buying the other out when that owner passes away. So next slide. Establish a decision-making plan. So this is really where a lot of times in the business succession kind of process, things break down. And just like Kirby said previously, when she's discussing the, trust versus will and probate route, and having to seeking court approval for operating the business and making sure somebody actually has the authority. This is right here an issue where people don't have clearly defined roles or responsibilities. We might be in a position where someone passes away and their interest transfers, or their interest is stuck in a trust or stuck in the probate process, but that person that's the owner might also be the president of the business and operating the day-to-day operations of the business. So the ownership might change, but we're also having to make sure in this business succession process that we're thinking about not just ownership, which is, I think, one of the biggest downfalls in the process, and the biggest area where mistakes happen is we're just thinking about ownership and we're not thinking about day-to-day business operations. So we need to make sure that we're thinking about not just who's going to take over as an owner, but thinking about who is going to step in and take on roles and responsibilities in the day-to-day operations of the business. It's also important in that process to think about establishing methods for dispute resolution. It might be a matter of the ownership was all with one parent, and then when that parent passes away, you have two children that then are taking on the business 50-50. So, the organizational documents might not have considered how to deal with dispute resolution in the business because there was one owner who, that decision, won the day because there was only one person. So making sure that we're outlining and thinking through dispute resolution in this business succession plan. And, I know Kirby and Sidney can attest to this, especially when you're talking about people inheriting a business. Everybody agrees until they don't. And so it's really important, when you're talking about, inheriting things, and you want to think that, every parent and every family wants to think that their family will be nice and get along and go through the process in an appropriate manner. But unfortunately, when we start talking about money and splitting things up, it's, often, very likely that there will be some disagreements, even if they're not big. So we need to make sure that we're figuring out how to address those. Okay, next slide. Developing a team of advisors. I would hope that if you're already in that kind of estate planning process, that you've already got these people in place, but these parties might be slightly different, or you might need to bring other people into the fold that are involved in the business if we're talking about a business succession plan as well. So you should absolutely have your attorney and accountant and any financial planner that you have involved. There might be situations of legal, tax, and family issues that need to be addressed associated with the succession, depending on where we are with the estate tax. We might be seeing that lowered, the estate tax exemption in the future. And I've had families and businesses where, the estate of the family was worth a lot of money. And when the parent passed away, it might subject the family to some estate taxes, but the estate tax couldn't be paid unless, we sell the business. So those are things that your legal and your tax team can be addressing with you, figuring out if there are any, estate or income tax ramifications to these transfers that you need to be evaluating and need to be dealing with, because oftentimes there are, great solutions that we can put in place to make sure that, what you want to happen actually happens. But if you don't have the right people sitting at the table, then the right questions aren't getting asked. So making sure you have the proper team in place is absolutely essential. Okay. Establishing an internal business succession plan. So we've talked about on a larger, broad scale, who do we want to take over the business? How do we want that transfer to take place? Then what happens from there, once our large scale goals and objectives have been identified, is putting all of the small pieces in place within the company. So some of the topics that you would need to cover, and this is a very small list a condensed, very short version of a ton of things that need to be evaluated in this process. One would be the method for evaluating the business. So if you are going to either transfer a portion or somebody's going to be bought out in the process, you have to figure out how to evaluate what the business is worth. And it's always easiest to do that, like Kirby mentioned, on the front end when everybody's agreeing. That's always the best time for everybody to reach a solution, is when we're all on the same page. So, this might be, I have some clients who have a meeting every year to set the valuation of business. And then if somebody passed away in that year or something changed, then that most current valuation would be used. Other times you would put a very specific model in, but that's something that needs to be addressed. And sometimes we can eliminate some much larger costs, as if we don't have some method for evaluating the business outline, we might have to bring in an outside firm to do, a full-blown business valuation, and those can be very costly. So as with everything, planning on the front end, it might be a little bit more money on the front end, but it oftentimes can save a bunch of money when the process is actually being executed. The need for life insurance policies. If one business partner is going to be bought out and that's the plan, where is that liquidity coming from? It might be necessary for the business to purchase life insurance policies on an owner and have key man policies, so that if someone passes away, there's actually the liquidity there within the business to buy out those interests. Or else, we could be in another situation where the business is having to sell off assets to buy out this partner. Making sure we have standard operating procedures. I see with a lot of companies, we don't actually have any of our procedures or policies documented as far as how we operate the business. So that can be a problem and lead to a big issue in consistency when we lose an owner and have that transfer, because the processes are not written down anywhere. Buy-sell agreements, if the idea is for one partner to be bought out upon the death of someone, or if someone decides to leave, a lot of those terms can be outlined in buy-sell agreements so that it's covered by separate agreement and there's a complete policy put in place. And then the existing governing documents aren't necessarily muddled with that kind of process. We can pull it out and put it in a separate agreement. And then just dispute resolution. I know I've kind of beat that to death, but that is always an issue in succession plan, is making sure that we outline how decisions are made and the process for evaluating and addressing any disputes among any successors or existing owners. Okay, and the last step will be, again, tying back to reviewing the owner's estate plan. Like I said, any successful business succession plan has to be executed in conjunction with the owner's estate plan. So if we have an inconsistency there, or business partners are not, talking through that process, I know some of those things can be so personal and can be difficult to talk about. But it's always easiest to have those conversations and make sure everybody is prepared and has a plan, and know that the professionals that you would be hiring to assist you with that project. We deal with this every day. We talk to families, and we know that it's a hard conversation. Often is a hard conversation, and nobody wants to talk about what will happen when I die. It's just not something that is, something anybody wants to address on a Wednesday afternoon. But the fact that you all are here and listening to the, these steps and these recommendations that we're making, shows that you are, acknowledge that this is an important issue, and anything that, the professionals are doing is, all the steps are going to make the process easier in the long run. So That's our job, is to make sure that we can make the process as seamless as possible and to make things happen the way that you want them to. I always tell our clients, when they start coming to us and say, well, what can I do? And I always like to tell my clients, well, tell me what you want to do. And if, once you tell me what you want to do, we can most likely figure out how to accomplish just that. And if we can't, we're going to then know what your objectives are and be able to get you as close to that as you would like. So that is it for my overview on business succession planning. We've got my information along with Kirby and Sidney's. So we have there all of our phone numbers and all of our email addresses. And we have a few minutes left to talk about any questions anybody might have.
Yes, thanks ladies for your presentation. We did have a question come through, and anybody that didn't see the message in the chat, if you do have a question you'd like to have answered, feel free to post that in the chat box. But like I said, we did have a question come through a little bit earlier. This person wants to know, they currently have a POA for their mom who's in a skilled nursing facility. They're wanting to know if they should get guardian status and what are the advantages.
I'd be happy to address that question. This is Kirby. So a power of attorney is effective while your mother is living. It is no longer effective upon her passing. She would also have the right to, so let me back up for a second. A guardianship removes her right to make her own decisions. A power of attorney allows you to also make decisions for her, but does not remove that right from her. So the threshold for establishing a guardianship is whether or not that person is capable of handling their finances and daily activities, and whether or not through a doctor's recommendation, the doctor feels that that there could be some harm to them, their person, or to their estate by continuing to allow them to make their own decisions. So, for example, and this is one that I've had. We had a lady that needed to be placed in a nursing home. The home health care was just unable to care for her in her house. It was unsafe. She was continuing to try to go up and down stairs. So they placed her in a nursing home facility. But she kept trying to leave. And she had the right to leave. So they got a guardianship over her. And at that point, someone else could say to the nursing home staff, you cannot allow her to leave. We have guardianship. We have the right to make decisions for her. She no longer has those rights. Again, a doctor had said that she didn't have the capacity to make those decisions for herself. So that is really what we look at when we're evaluating whether a guardianship is needed, is whether or not that person has the capacity to continue to handle their daily activities and their finances. And we can break those out if they can make financial decisions for themselves, or whether they need help on their daily activities. Those two things can be separated as well. So I hope that helps answer a little bit of your question.
Great. We have another one that just came in. This question says, if carrying life insurance on a business partner in order to have liquidity to buy out the other partner, who should be the beneficiary? The surviving partner, the business, or the owner's estate?
I'll jump in on this one. Generally, when we're doing, first of all, it's going to depend on what the governing documents say. So if the plan is for the business to buy the owner out, then the business would need to be the one that was the beneficiary of that policy. If the plan is to informally have, if the documents say that the other owner can buy out the business, it might make sense to have the other owner be the beneficiary. So a lot of that is going to depend on what the governing documents say. Now, generally, it's either going to be the other owner having the policy, or it's going to be the business. If the money goes to the estate, then that's just part of the estate. And there's not necessarily, the estate can't be bound to then there's not really a mechanism for buying out those interests if that interest goes directly to the estate, because then it goes to the estate and, the beneficiaries there have the right to that money. I've had a situation that I can't remember if I did this with Kirby or Sidney. I did it with one of them, but I had a situation where that was the intent. The intent was for, this life insurance policy to be buying out the interest. Well, instead of actually putting, the company that would be buying out as the beneficiary, they made the beneficiaries of the person's estate that would be getting the interest. So then we had a weird situation where that life insurance policy was always intended to, pay for those interests, and then the company was supposed to get the interest back. Well, the way things were set up, legally, that money went to the beneficiaries. And so then the beneficiary said, well, we're also entitled to the interest. So the company had tried to do things right, and then we're in a position where they've been funding this life insurance policy that then went to this beneficiary, and then they were having to figure out a way to buy out the beneficiary also. So it's real important to make sure that you're visiting with professionals about what the objectives are and what the documents are, because it's real easy for wires to get crossed. And in that case, somebody kind of benefited, got a lot of extra benefit there. And, the company was out extra money. So, and in that situation, all you're having to do is, hoping that people are going to be, nice and agree to something that they don't have any legal responsibility to agree to.
Which I will say, that doesn't happen all that often, right, Kayleigh? Sometimes that's not that's what you plan, but unfortunately, our job is the what if.
Thanks for that. We have time for one more. We had 3 final questions come in all about cost. And so can you go over in the last minute or so, price difference in setting up a trust versus a will, going to probate? What are folks looking at when they're discussing that?
Okay, I'm happy to jump in on this. So typically for an individual with a basic estate plan, you're probably looking about $1,500. And that would include, so whether or not it's a trust or a will, it's like I said earlier, it's a lot of times the same price, because we are still putting that same information into a will as we would into a trust. The difference is the will with a trust is what we call a pour-over will, and it's very short, sweet, to the point, says dump everything into the trust. So typically you see with a couple, their documents are very corresponding. And so you're probably looking at about $2,500 to $3,000 for a joint estate plan. And Kayleigh, I'll let you jump in for business succession planning if you don't mind.
Absolutely. Now, business succession plan, I think there's not a direct quote that we can give, because everyone is so individualistic with each plan. Where we've got estate plans that a lot of them are very similar, or kind of have the same pieces. That's not the case with business succession planning, because we are talking about, do we have a corporation? Do we have an S corp? Do we have an LLC? Is there one member? Are there 2? Are there 7? Do we have buy-sell agreements already in place? What does the operating agreement say? So that process with the business succession planning process is always going to be more expensive than the estate plan process. So, how much that's going to cost is really going to depend on what's already done. Because sometimes clients come to us and have an estate plan in place, and they have all of their corporate documents that are very organized, and it's just a matter of helping, coordinate those things and fill in the missing pieces. Sometimes people come to us with nothing. So that being said, based on Kirby's kind of quotes for estate planning, the business succession process is going to be generally more expensive. but sometimes it's tied into the estate planning process, and some of those costs are kind of overlapping. So that's not really a very, I know, very specific answer, but because there's no one size fits all, there's not really a quote, because we might be preparing one document for one business succession plan and putting together, 7 documents for another.
Great. Thank you for answering that question, and thank you for this presentation today. I know it's been extremely valuable. I'm getting messages in here. Thanks for this. Thank you, thank you, thank you. Great job, ladies. So thank you again to Kayleigh, Kirby, and Sidney for this presentation on business succession and estate planning. Hope you find it valuable. If you missed any part of it, this is recorded. It's also on our Facebook page. You can check that out. We'll also send out an email afterwards for those that registered if you missed it. One last shout out to our awesome sponsors, including Wright Lindsey Jennings, also Frost, Simmons, and the Little Rock Chamber for all of the continued support. If you have any questions around this topic, they left their contact information. Feel free to reach out to them about your needs or your concerns or your questions. Otherwise, we hope to see you again at one of our programs. Thank you so much. Have a great day.